Yes, good evening to all the participants of the JCJ 2022 main examination, and please read what I posted on the screen. Anyone can unmute and read what I posted on the screen. Anyone can unmute and read what I posted on the screen.
Welcome to our online class, JCJ 2022 main exam, valid, void and voidable marriage under Hindu Marriage Act 1955, divorce, restoration of conjugal rights, Professor Dr. Mohammed Saheb Hussain, SAUT,
Yes.
Mombasa, Tanzania.
Okay, thank you very much. That means you are hearing me and I'm hearing you. You could see my screen, so we can proceed. So, do you want to say anything, Sir Venunath? Or later?
Hello.
Okay, let me start my class now. So, the essential conditions of the valid marriage. So, actually, in the Hindu law, there are how many acts are there? Hindu Marriage Act 1955, Hindu Succession Act 1956, Hindu Minority and Guardianship Act 1956, Hindu Adoption and Maintenance Act of 1956, Hindu Disposition Property Act 1916. There is one more act also there. What is that? Irrespective of the caste and creed, one can marry. What is that act?
Special Marriage Act.
Special Marriage Act, sir.
I appreciate. Can you say the year? Can you say the year?
Yes, sir.
What is that?
No, sir. No, sir. No, sir. No.
To my knowledge, it is also 1956. Let me check it. Special Marriage Act.
54.
1954. It is not 1956, it's a 1954 because the rest of the most acts are 1956 except the Hindu Marriage Act is 1955. So before that, the Special Marriage Act 1954 is there. Okay, now let us go to our point, the introduction. What are the 5 conditions are there for the valid marriage? Especially Section 5 provides that the marriage can be solemnized between the two Hindus if the following conditions are fulfilled. Generally, that word used solemnized. Why do you say solemnized? Why should not we say conducted? Anyone?
Solomonize means when you have the rituals in place.
Solemnized means holy.
It is a holy, it is a spiritual, and hence we can say solemnized. It is a sacrosanct, and hence we can say, and we don't say exam is solemnized on so and so day, exam is conducted on so and so day. Is it clear?
Yeah.
I appreciate. Okay. Section 5 provides the 5 essential conditions. Number 1, spouse living at the time of the marriage. Neither of the parties to the marriage should have any spouse living at the time of marriage. That means if the husband or the wife, anyone goes for the marriage, the spouse should not living one at the time. So that is called the spouse living at the time of marriage. If they solemnize the marriage, second marriage, then it becomes a bigamy. Is it clear? Say yes.
Yes.
Of course, very good. I don't ask the bigamy provision. Article, not article, section. What is a bigamy section?
Section.
494, sir.
Is it 94 or 96?
94, sir.
94 of IPC.
Yeah. Bigamy. Because this is second method is very good. Bigamy section. Okay, bigamy. Let me say the section. Because some sections should be on our tip of the tongue. Yeah, you are right. 494, Gausia is right. It is the bigamy section is 494 of the IPC. So now let us go back again to our study. So one of the spouse should not be living at the time and should be in living, then it is the amount to the bigamy. The second condition is that at the time of the marriage, neither party to the marriage should be incapable of giving the valid consent for the marriage. That means they should have the sound mind. Can you tell me the adage or a maxim about the sound mind or health? Any maxim? No, don't say maxim because generally the maxim will say in the legal terminology. Adage, sameta, Telugu, on the sound mind. If you don't know, you say pass on. Don't waste the time.
Pass on, sir.
A sound mind is in sound body. Repeat.
A sound mind in the sound body.
It is the African terminology, African proverb. But there is it is a Asian proverb. It is a Asian proverb, but African proverb is a healthy mind is in healthy body. Repeat.
A healthy mind in a healthy body.
Good. Now you know the two African proverb as well as the Asian
Yes,
proverb.
sir.
Say. Okay, number third, at the time of marriage, though capable of giving the valid consent, he is suffering from any mental disorder of any such type or such extent that is unfit for the marriage or procreating the children. Suppose if he is having any diseases, at the time, he could not give the valid consent at the time. And moreover, if it is any deficiency would be there, he could not procreate the children. Is it clear?
Yes, sir.
Say yes.
Yes.
So fourth one, at the time of the marriage has been subject to recurring attacks of insanity. Like insanity, somorogamo. What do you say somorogam in English? Yes?
Pass on.
It is epilepsy.
Epilepsy.
Yeah. So that is another condition would be there. And the fifth is the age of the bridegroom and the bride. Of course, 21 and 18 years. Of course, it is increased, but I don't know whether it is going to be implemented or not. What
It
is
is
the
only
increased age?
it is only a proposal made. It is not
What is the
being
increased
implemented.
age?
No. It's 21 and 18 only. It is only proposal which has been made.
I say proposed one.
Yes.
What would be the age of the proposed one?
21 years.
Both of them.
Yes.
Okay. Now the sixth condition is the party must not be within the degree of the prohibited relationship. Exception to this is only the provided if the custom or usage governing them allows such a marriage. What is another name for the Latin? What is the another name in Hindu terminology? Close blood relationship. What is another terminology for the prohibited relationship?
Sapinda relation, sir.
Okay, that is one way. Next. Next.
Sagotra relation.
Next. Consanguinity.
Consanguinity.
But you are not saying that word. Okay. Sapinda also it's prohibited. Close relationship also prohibited. Consanguinity also prohibited. The parties must not be sapindas of each other. Exception to these provided by the permission of the custom usage governing the parties. Again, the exception is there. So, description of the conditions are concerned. Number one, monogamy. What is meant by monogamy?
One male marrying one female only.
Okay. What about the one man and many wives?
Polygamy.
And one woman and many husbands?
Polyandry.
Very good. I appreciate. So monogamy, Hindu Marriage Act 1955 provides the rule of monogamy and prohibits the polygamy and polyandry. The Hindu before this law could marry any number of wives, even if it had a wife or wives at the time, and earlier. But later on, the practice was disfavored. Then wife more than one husband at one time, this is called the polyandry. Of course, in 1955, polygamy was recognized in Hindu law, but polyandry was never permitted. But Section 17 would render offending party liable for the prosecution under the 494. There's the bigamy, and 495 for the punishment. Am I right? Punishment parties in 495? Yes or no?
No.
sir.
Then what is 495?
It
Okay.
is also another offense relating to marriage.
Okay. The second marriage is the lifetime of the spouse. The first marriage will be against the law and considered void. And if the second marriage were contracted outside India in order to prosecute a person of bigamy, it is necessary to prove that she already has a living spouse or prior marriage has been duly celebrated with the performance of the ceremony. So, Hindu law propagates monogamy. Christian law propagates.
Monogamy.
Say loudly, monogamy. Whatever the Islamic law,
Polygamy, sir.
it is only the theoretical, practical, none. Okay, second is sanity or the mental capacity. There is a section 5, I think the provision 2 or class 2, provides about the mental capacity of the spouse at the time of the marriage. It was provided in the original act that the neither party to the marriage should be an idiot or a lunatic or an insane person. The Marriage Laws Amendment Act 1976 framed the clause and explained the insanity or mental disorder. The clause provided that at the time of the marriage, neither the party, first bullet, should be incapable of giving the valid consent to it in consequence of the unsoundness of mind. Second bullet, though capable of giving the valid consent has been suffering from the mental disorder of such a kind or kind such extent to be unfit for the marriage or procreation of the children. And third bullet, has been subject to the recurrent attack of the insanity or epilepsy. So these are the conditions would be there where a person could not give the free consent. Thus, a mental incapacity of the form affecting the very purpose of the marriage has been ground of the viability of the marriage. The mental disorder of the insanity must be in existence at the time of the marriage. Such a marriage may be declared viable under the section 12 of the Act. But if a person subsequent to the date of the marriage suffer from the mental disorder or insanity, the provision of this clause are not contravened, because it applies to the such where the parties are insane at the time of the marriage. At the time of the marriage, when he is giving the consent, but he doesn't have any mental disorder, but later if it is developed over there, then that will be the ground for the dissolution of the marriage. Is it clear?
Yes, sir.
Okay, number third, age of parties to marriage. Of course, according to the Hindu Marriage Act, 21 and 18 would be there. But as for the religious marriage and customary marriages are concerned, would it be allowed? Yes? Child marriages are punished or not?
Yes,
Yeah,
sir.
punish.
Now it is definitely punished. Of course, no child marriage nowadays.
But as per Muslim law, she is entitled to marry when she attains the age of 15 years.
Yes, that they say the puberty, they say the Privy Council has given the minimum age for that is the 15 years age. But in the Muslims also, nobody is going to marry within the limit of the 15 years, unless until love is blind. Am I right?
Yes.
Okay. Go for the beyond the prohibited degree. That is the section 5, class 4. Prohibit the marriage between the persons who are within the prohibited degree of a relationship with each other. That is section 3G. Provides two persons are said to be within the degree prohibited relationship. Condition they have given number 1. If one is a lineal ascendant of the other. Ascendants means who?
Generations, one after one.
Upper layer.
Upper layer. From grandfather to father to son to grandson, those are called
Descendants.
They are the descendants. Upper level ascendants. If one was wife or husband, lineal ascendants or descendants, both the way. Either wife or husband, both the sides. Either ascendants or descendants is the prohibited degree. If one of the wife of the brother of his father or mother's brother or the grandfather's grandfather, brother or the other also comes under the prohibited degree. If the two are the brothers and sisters, uncle and niece, aunt and nephew, and children of the brother and sister of the two brothers and sister of the two brothers or sisters, they also comes under the prohibited degree.
But in Hindu law, Mama Banje they marry sometimes.
Now it is no more invalid now. Mama bidda.
वो चलता है अभी भी चलता है वो no more valid क्या it still goes on.
Yeah. But
But
now who will marry now? Maternal.
No. But any marriages which follows as a tradition that is
Yeah.
allowed.
That is traditionally it will be allowed, but not according to the Hindu Marriage Act.
Yes, this tradition because this mama marrying Banje and all this has happened for many years. So that tradition still continues. That is allowed still.
Do you think that the girls are deaf enough to marry in such a way?
No, that's secondary. That is secondary.
Okay.
But,
A man of a reasonable common sense never go. Okay, let us see that first relationship by half and uterine blood as well as the full blood. Even a legitimate blood relationship as well as the legitimate also. In the both the way they comes under the prohibited degree. And the relations of adoption as well as the blood. All of terms of the relationship in those clauses shall be construed accordingly. But if the custom and usage governing each party to the parties allow marriage within the degree of the prohibited relationship, then such a marriage will be the valid or binding. Traditional and customary marriages are concerned. But I don't think that it is going on except in nomadic tribes. The fifth point is beyond the Sapinda relationship. There is a section 5.4 prohibits the marriage between the person who are the Sapindas of each other. A marriage in contravention of this clause that it will be void or may be so declared under the section 11 of the persons contravening to the provision of this clause would be punishable under the section 18. The word Sapinda means a relation connected through the same body. According to the section 3F of the Sapinda relations we define. Yes, can anyone unmute and read what is that first condition? Class. Read loudly.
The relation with reference to any person extended as far as the third generation inclusive in the line of ascent through the mother and the fifth generation inclusive in the line of the ascent through the father, the line being traced upwards in each case from the person concerned who is to be counted as the first generation.
Yeah. But anyway, they have counted either the ascendant side or descendant side. That comes under the Sabindas as per the 3F is concerned. And the second point, they clearly say two persons are said to be the Sapindas of each other if one is a lineal ascendant of other within the limits of the Sapinda relationship, with the limits of Sapinda relationship with the reference to each of them. But any close blood relations either from the ascendant side or from the descendant side, either from the father side or from the mother side, those comes under the prohibited degree. So, in one way, in another way, Sapinda's marriages are prohibited.
Illegal.
So, marriage under this is a sacrament. So, Hindu marriage is a sacrament. That's why they say, solemnize, requires the above mentioned condition of the marriage. Thus, in order to constitute a valid Hindu marriage, under Hindu law, party to the marriage should be monogamous and should have a sound mind, should be a major by age, and should be beyond the prohibited degree. A marriage fulfilling these conditions is considered to be the valid and have effect under the Hindu Marriage Act. So, that what we studied now is the valid marriage. So, valid marriage, to sum up, what are the conditions? Can we review it?
6 conditions.
Okay, give the one condition, later on another participant give the another condition.
Either of them should not be married.
Okay,
Point one.
that means the spouse should not be living at the time of the marriage.
No, I would not say that. Living or dead is I'm not. I mean to say is that either the boy or the girl, they should not be married earlier. Both of them should not be having spouse. They should be spinster and bachelor like.
Okay, you want to convey in that line.
Yes, I want to make it clearly.
Okay, next. Hosea.
Either one of them- yeah, okay.
Sir, it's not like that, sir. It is spinster, like it's not like that. Though he has married or she has married, the spouse is not living. And if he or she marries again, then it is valid, sir.
Okay, one
Divorce of
point is there. One point one want to make it clear. A married man, a married woman, provided she took the divorce, or
Yeah.
a married man or unmarried girl or woman, if she give the consent more than 18 years. Vice versa also. But compatibility also very much important factor.
Both of them should not have spouses at the time of the marriage.
Yes, that is the living spouses. And compatibility is concerned, a married man and a unmarried girl, compatibility will not be there.
That differ from cases to case.
Yeah, because a white cloth needs only white cloth to patch, and a black cloth needs only black cloth to patch. But white cloth and black patch, sir, is it a design?
Passion.
That is only for the few days. Keep in mind, fashion is always in the few days.
Yes, sir.
Bell bottom. Anybody is wearing the bell bottom now? Barrel. Anybody is wearing tight pant? Anybody is wearing?
Sir, that trend will come after another 10 years. Don't worry.
So that is what I want to say is, but still we can enlarge it because I have some other point here. See, in the tribals, this will not be allowed. Either the age or the sapindas. Here, tribals for different parts of India, these tribals are governed under the traditional laws and usages, especially tribal circumstances. Now I would like to ask, endogamy and exogamy, any idea?
Yes, sir. Endogamy means sakula vivaham. Exogamy means bahirvivaham.
What is
Okay.
that? Bahira Vigam means?
Yes, endogamy here, I put it on the screen. Where a man cannot marry a woman who is of his relation. That is endogamy. And exogamy, a man cannot marry a woman who belongs to another tribe. So endogamy and exogamy are illegal in view of Hindu Marriage Act, 1955. Another is sanskara. A Hindu marriage was a religious ceremony and also a sanskara, sanskara, within parentheses, performed as a purification rite. R-I-T-E, rite. Religious rite. R-I-T-E, rite. But when you say add W-R-I-T, that is a rite. Is it clear? Religious rites and rites, they are both different. So is a sanskara is a purification performed as a, if a man who is not married, in the mythology, he is a half man. And the people say he will not go to the hell or heaven. And he will be suspended in the middle. Anyone?
Don't worry. Nowadays, no one go to heaven. Everyone go to hell only.
See, one person asked, Sir, in the heaven can we smoke? They said, okay, you can smoke, but getting the fire, you have to go to the
Hell.
that is the answer is given over there. But anyway, of course, it is I don't blame the ladies. Many ladies are there in heaven, and many lawyers are there in, is it heaven or hell? Many ladies are there in the hell, and many lawyers are there in the hell. Is it a defamation?
No.
Answer no. It's a fair comment. So let us see in another way also. In the voidable marriage, none of these parties have a spouse living at the time of the marriage. Yes, that is the condition which made it. During the time of the marriage, neither party should be incapable of giving the valid consent. But I want to see any case law is given over there or not. But here, repeated attacks of insanity is there. Yes, epilepsy like that. under the marriageable age 21 and 18 respectively, and there should not be any prohibited relationship. And the nullity of marriage, when you say the nullity of marriage, if there are any impediments or obstructions, then the party cannot marry each other. If someone marries, there are many obstructions in the marriage process, it is not a valid marriage. Here the impediments are divided into two types. One is absolute impediment, another is relative impediment. So what is an absolute impediment? A fact that disqualifies a person from lawful marriage exists and the marriage is void. An invalid marriage from a beginning. Ab initio. In relative impediment, an impediment forbids marriage with a certain person exists and the marriage is voidable. One party cannot avoid the marriage. These impediments give rise to the classification of the marriage, which are void marriages or voidable marriages. So, provision of void and voidable marriage under the Hindu Marriage Act is given. Section 11 says about the void marriages. VOID, void. A marriage is considered void under the Hindu Marriage Act 1955 if it does not fulfill the following conditions. Number one, bigamy, as we discussed already. Is it clear?
Yes, sir.
Next is prohibited relationship, consanguinity, sapindas, either lineal side of the mother or father or the descendant either from the mother side or father. One illustration he has given here. There are two parties, A and B, where A is the husband and B is his wife. They both went on a relationship which is prohibited by law. The marriage can also be called void marriage. So, sapindas, a marriage between the parties who are sapindas, or in other words, marriage between the parties who are of his or her relations of the same family. Illustration, there are two parties, A and B, where A is the husband and B is the wife, and who has blood relation, close relation to A, which can also be termed as sapinda. So, this process will be treated as a void. So, consequences of void marriage. What are the consequences of void marriage? The parties does not have the position of the husband and wife in void in the ab initio. The children called are legitimate in a void marriage. Of course, section 16 of the Hindu Marriage 1955. What is the another name for the legitimate? Yes?
Legal,
Okay. Illegitimate.
illegal,
What is the another synonym? We generally say bastard. No, we don't say bastard. But a polished language, we can say extramarital. Whether extramarital children are legitimate? Answer is
yes,
No.
Yes, yes, yes.
here clearly given. Children are called legitimate in void marriages, as per the section 61 of the Hindu Marriage Act of 1955. At the no fault of the child, why the child should be victimized?
Even if a child is born out of living relation, then also he is said to be a legitimate child.
Yes. And he is entitled for the
Property.
inheritance. What is the distinction between inheritance and succession?
Good question.
Yes, anyone? If you don't know, say pass on. I will give the answer.
I know the answer. I know the answer. I want the participant to tell.
sir, tell me, sir. Tell us, sir.
You inherit the property through the succession.
From great grandfather to father to grandfather, all this is succession. And inheritance is from my
Process
father
is
to my-
called succession, and the aim is called, means total aim is called inheritance. Object, motto, endpoint. So, mutual rights and obligation are not present in the void marriage. So, voidable marriage, section 12 clearly says a marriage is voidable on either side of the parties known as voidable marriage. It will be valid unless the position for invalidating the marriage is made. The marriage is to be declared void by competent court under the Hindu Marriage Act 1955. The parties of such marriage have to decide whether they want to go with such a marriage or make it invalid. The party to the marriage is not capable of giving the consent due to the unsoundness of mind. Illustration is, there are two parties, A and B, where A is the husband and B is his wife. B gave the consent of the marriage when she was suffering from an unsound mind. After some years, B gets cured and realizes that her consent was invalid and this was voidable marriage. Because during the time of the consent, B, she was in unsound mind. So, this ground of the voidable marriage. Whatever the importance is,
Excuse me, sir.
whatever, yeah, please ask
Sir, I
me.
didn't understand the difference
It
between.
is not a valid marriage.
Okay, no. Let Gausia will doubt clear, then I will come to the Venunath. Yes, Gausia.
Sir, I didn't understand the difference between inheritance and succession, sir.
You inherit the property through the law of succession.
Okay, sir.
Succession is the mode. Did you get my point?
Yes, sir.
There is a law of succession is there, but don't say the law of inheritance.
No, it's very simple. From great grandfather to grandfather to father to you, it is called succession. That process is called inheritance. Simple language.
See,
Process is called in.
yeah, succession. You get the succession of the property, and we'll say, did you inherit the property? Means coming from the ancient forefathers. You inherit the property through the
Ancestors.
succession. When you say married,
Sir.
then the process of solemnization should be there when the conditions are fulfilled. The marriage is solemnized. Processing is called succession, and getting the property is called inheritance. Any doubt?
ढंग से बनाते भाई.
Any doubt? Shall I proceed?
Yes, sir.
Good, I appreciate. Yes, Venuna, do you want to add something? Venuna, do you want to add anything? Say no or yes.
No, continue.
Okay. But say, continue, sir. I say no. Okay, the party is suffering from the mental disorder which makes her unfit for the reproduction of the children. Illustration, there are two parties, A and B, where A is the husband, B is the wife. If B is suffering from the mental disorder due to which she is unfit for the reproduction of children, this can be a ground for the voidable marriage. What is that woman is called who doesn't bear the children? She cannot conceive. There is a specific name is there.
Barren.
Yes, you are right. BARREN, barren woman. So if the party has been suffering from the repeated attacks of the insanity, illustration, there are two parties A and B where the A is the husband, B is the wife. Anyone from A or B is suffering from a repeated attacks of insanity. This can also be a ground for a voidable marriage. Means, in the beginning they married, and the marriage is a valid marriage, but because of some impediment would be there, it becomes voidable if a party goes to the court. Is it clear?
Yes, sir.
Good. The consent of marriage by either of the parties is done by force by fraud. Illustration, there are two parties A and B where A is the husband, B is the wife. If either of the party gave the consent to the marriage by force or fraud, I say force or fraud, both the way. In the Telugu, if I want to say, Chinnammayani chupetti Peddammayani chinru. And Venunath showing the younger daughter and given the marriage for the elder daughter.
Yeah, understood.
That is by fraud. Number one. Number two, by force. keeping the revolver at the zero range near the temple or at the temple, then it is a force. Is it clear? Is it
Yes,
clear?
yes, yes. Yes, 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 yes.
What is meant by temple?
Mata nahi.
In Telugu,
इनके बाजू में which is above the which is above your ear, that is called temple.
Kanta, adjacent to the eyebrow.
Just to the brow and above the ear.
Yes, yes. The side lax.
Yes.
So, if either of the parties is underaged, like a bridegroom under the age of 21 years and the bride is under the age of 18 years, if they marry together, but when they reach to the majority, age of the respectable age for the marriage, at the time, they can go to the court and they say, voidable marriage. If the respondent is a pregnant with a child of some other than bridegroom while marrying, at the time also it's a voidable marriage. In India, if you say a girl or a woman who is not married, are you a pregnant? It is amount to defamation. But if you say in Africa, it is not at all a defamation. So defamation varies from
Culture to culture.
place to place, culture to culture. So necessary condition to be fulfilled, a petition under the section 12 of the nullity of a voidable marriage. Number one, on the plea of fraud, application of force on marriage, a petition can be filed before the court within 1 year of discovery of such a fraud or application of force. Of course, limitation is given over here. I don't think that the limitation is relaxed now.
No, it is the same. Unless you want to take divorce, you have to file only after 1 year.
Mutual consent,
No, mutual consents, no.
they relaxed
1
it.
year. You have to wait for 1 year, but however, the High Court in its discretion can give within 6 months.
Yeah. Second point, the allegation based upon which the petition is filed was beyond the knowledge of the petitioner at the time of the solemnization of the marriage. If the one of the party or any one of the party doesn't know, but later on they came to know, yes, it can be voidable. Or it can lead to even nullity of a voidable marriage. The petition on such allegation must be presented in the court within 1 year of the knowledge of such facts. No sexual relationship is established after knowing about the alleged fact. Even that also a ground. What about the desertion?
Yeah.
What about the desertion?
For that also, the duration is 1 year.
Do you think that only the desertion is 1 year or 2 consecutive years?
2 years, sir.
2 years.
2 years,
2
2
years.
years.
2 years. Sorry. 2
That
years.
to be 2 consecutive years.
Yes. Sorry.
Meanwhile, in the 2 years, if there is a BBC, it is not amount to desertion.
No, I didn't get you. What you are saying? If it is?
Oh, you did not know the full form of the BBC.
No.
BBC, initialism, body to body contact, not
Okay.
British Broad Corporation. Every time you say sexual intercourse, it will not be quite good. A polished language is BBC.
But the legal language is sexual intercourse only.
So every time it should not be that much good enough. So a polished language I used.
Because one of the High Court judge, one of the Bombay High Court judge has made a comment on body to body touching. It's not an offense. So she was later.
But you don't understand it. I made the code like that. I codified it for our understanding. It is not a universal.
Yeah.
So difference between the void and voidable marriage is a wife does not have the right to claim maintenance in the void marriage. In the voidable, a wife has the right to claim maintenance in the voidable marriage. Now, In a void marriage, the parties don't have the status of husband and wife. And here in the voidable marriage, husband and wife has the status in the voidable marriage. What about the inheritance? Children will get the inheritance.
Unless they have children.
But if the void marriage, she will not get. It is a nullity. And in a voidable marriage, degree of nullity is required later. A void marriage, none of the eye of law. They are valid as a husband and wife. A void marriage is to be declared void by a competent court, especially for the nullity is concerned. And who is having the right to entertain the case of family
court.
issues?
Family court.
But there is a rank is there. First class judicial magistrate.
First class judicial magistrate.
The children in a void marriage are treated as illegitimate. And the children in the voidable marriage are treated as illegitimate, but this distinction is declared deleted by the Supreme Court and said a child cannot be said termed as illegitimate. So legitimate is of the children under the void and voidable marriage. A legitimacy of children under the void and voidable marriage are specified under section 16 of the Hindu Marriage Act. In a void marriage, any children born out shall be treated as illegitimate. In a voidable marriage, any child born marital relationship subsequently declared nullity by court shall be termed as illegitimate because of the Supreme Court decision. Even if the marriage under the section 11, void marriages, or section 12, which is declared as the null and void, notwithstanding such a circumstance, the child born out of such a marriage is held to be legitimate. It means,
Sir, by any reason, whether it's void, voidable, or illegal marriage, any children born out of them, they are said to be legitimate children.
notwithstanding, in any circumstances.
Yes.
So, if prior to the marriage the bride was pregnant and gave birth to a child after the marriage, such child cannot be treated as illegitimate because she was conceived with the another husband. Because the child was born out of the marital relationship, means not the tie of the marital relationship. And the present marriage, therefore, the child born after the marriage having been conceived prior to the marriage is to be held illegitimate. If there are two parties, A and B, where A is a husband, B is a wife, during the time of the marriage, B is pregnant through another, after the marriage of A and B, the child born does not come from the marital relationship of A and B, the child will be termed as a illegitimate. Is it clear?
Yes.
Because the seed is sown by somebody else.
There's a duration for that also.
Of course.
240 days.
6 days. Of course, 6 months also, premature also there will be there, no? But generally,
No. It is said from the day of marriage, if the person is born prior to 240 days, he is said to be illegitimate.
Yeah.
Unless he is scientifically proved.
Yes.
240 days is the minimum.
Yes. So prior to the Hindu Marriage Act 1955, the parties to the marriage had no remedy to get out of the marriage. But Section 11 and Section 12 of the Hindu Marriage 1955 is a remedy for the parties who are in a void and voidable marriages. After the enactment of the Amendment Act 1976, the child born out of void or voidable marriage shall be termed as legitimate. There are certain grounds for a valid marriage under Section 5 of the Marriage Act 1955, which we enumerated, we discussed. If someone violates it, then it amounts to the void marriage or voidable marriages. So this is regarding the today's class is concerned, and the time is still, we do have in our hand 8:47, 3 minutes as per our wristwatch, but as per the mercy of the Cisco WebEx, we can also drag it. So if anybody wants to ask any question, you can ask me. Participants, or Venunada, you want to say anything, we can say.
No. I'll only talk from Monday onwards. I'll talk on my topic.
See, talk is
Because
a different
yesterday I had
terminology
Ganpati in my home.
and speak is different terminology. Did you get my point? In India, the card which you use it to show to the other person when you want to go and introduce him, you will send the card. What do you say the card? I repeat the question. A card which you want to show to somebody else that you are waiting for him to meet him. That card is called in India. Why you are keeping quiet? Did you understand my question?
Your voice is cracking, can't hear anything.
Okay. But if you send a card, CARD card, which containing your particulars, including your phone number and email, and name and designation, a new place to introduce yourself, what is the name of the card? I think you have the problem of my tone, my speak, my talk. Are you hearing me? Say yes or no. Are you hearing me? Munira. Mamata Kaur, are you hearing me?
Your voice is not clear.
Okay, better
It's
let me
breaking.
say goodbye. We'll meet you tomorrow and with us another restitution of the conjugal right and dissolution of the marriage. What is another name for the dissolution of the marriage?
Divorce.
What is the distinction between divorce and legal separation?
Legal separation, it doesn't dissolve the marriage, sir. There will be marital relationship will be there. In divorce, complete breakup of the marriage.
Yeah. And let us deal it tomorrow. Up to that extent, goodbye and have a good day. Jai Hind. End of the meeting. End meeting.
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे अहरह तव आभान प्रचारित सुनि तव उदार